The severability clause in California legislation, and how is that distinguished from a savings clause? On occasion, you might come across a severability or even a savings clause contained in a California bill. So basically, a severability clause is a statement in the bill by the legislature that if a part of a bill that's been enacted is subsequently held to be unconstitutional, then the unconstitutional provision or provisions don't invalidate the rest of the act or the law. It's a type of provision that saves the part of the law that is not invalidated by court action. Now, some states have a general severability clause applicable to all statutes. The general rule that's developed and applied by the courts generally is that if a portion of a statute is invalid or if it's unconstitutional, then the remaining portions of the statute are valid and enforceable if they can stand on their own. On the other hand, if the remaining portions are completely dependent on the stricken portions, then the remaining portions are also held invalid. So why are these severability clauses used? Well, sometimes a legislature wants a statute to either stand or fall on its own, and to avoid a potential court interpretation that might allow a statute to continue to remain in full force and effect after a portion of the statute has been invalidated by the court, a bill drafter may insert a severability or even a non-severability clause at or near the end of a bill. Now, as a general rule, a bill drafter should only use a severability clause when there's a possibility of a statute being partially invalidated, and it may not be clear that the intention of the legislature is that the bill be severed. However, others often advocate that a severability clause is unnecessary for legal purposes because courts have repeatedly ruled that regardless of the presence or absence of a severability clause in a statute, that the courts will sever the invalid portions from an otherwise valid law whenever they can. In other words, some legal observers argue that a severability clause ordinarily isn't necessary because both statutes and common law make statutory provisions severable themselves. Nonetheless, we do find these provisions scattered throughout California laws. Even our state constitution utilizes a provision. In Article 1, Section 31H, it provides in part that any provision held invalid shall be severable from the remaining portions of this section. Even Article 10B, Section 16 specifies, and to this end, the provisions of this article are severable. Numerous California statutes also contain severability clauses. For example, Government Code Section 9906, which is appropriately entitled Severability, it provides that if any provision of this chapter or the application of any such provision to any person or circumstance shall be held invalid, then the remainder of this chapter, to the extent it can be given effect, or the application of the provision to persons or circumstances other than those as to which it is held invalid, shall not be affected thereby, and to this end the provisions of this chapter are severable. There are many other examples. Usually the following language is found in a bill. The provisions of this bill are severable. If any provision of this bill or its application is held invalid, that invalidity shall not affect other provisions or applications that can be given effect without the invalid provision or application. So because some courts have given some level of weight to the inclusion of a severability clause in specific statutes, sometimes severability clauses are included in California legislative measures, especially in detailed controversial bills, or of course, if a legislative author specifically requests the inclusion of a severability clause in a bill, that will be done. But such clauses are generally not necessary in most legislation considered by the California legislature.